Welcome to LawSnoop, where we break down legal myths and uncover the truth behind complex cases. Today's topic is negligence in semi-truck lawsuits, myths that hurt victims. Before we begin, please remember this video is for educational purposes only. It does not provide legal advice, and for guidance on your specific situation, you should consult a licensed attorney. When it comes to semi-truck accident lawsuits, negligence is often misunderstood. One common myth is that negligence only applies if the driver was reckless. In reality, negligence can include failing to follow safety regulations, ignoring maintenance schedules, or even overloading cargo. Another myth is that proving negligence is simple. The truth is, it requires detailed evidence, from driver logs and inspection records to witness statements and expert testimony. Without this, victims may struggle to establish liability. Some people also believe that negligence automatically guarantees compensation. In fact, insurers and defense attorneys often challenge negligence claims, and victims must be prepared to show how the negligence directly caused harm. These myths can hurt victims by creating false expectations and weakening their cases. Understanding what negligence really means and how it's proven is essential to protecting your rights and securing fair compensation. Thanks for listening to LawSnoop, where we bust legal myths and bring clarity to complex issues. Be sure to join us for more episodes as we continue uncovering the truths behind the law. Remember, this video is for educational purposes only. Every case is unique, so always seek advice from a licensed attorney about your specific situation.